Welcome, everybody, to another Circle ID event, this one in partnership with the Edgemore Research Institute, founded by Dr. Steve Crocker. We're here today to discuss beyond WHOIS. We all know that a solution is needed to legally, reasonably, in a balanced way, access registration data information. And we have a very illustrious panel here to discuss what the challenges have been up to now, what the vision for the future could look like, and reactions to these discussions from those who are in the field doing the work. And with that, I'm going to hand the screen over to Dr. Crocker to get us started with a welcome and his input. Dr. Crocker.
Thank you very much, Lori. Thank you very much for agreeing to moderate and sort of run this whole program. Let me echo a point or two that you've made. We have a quite distinguished and illustrious set of people with a lot of experience. And what's even more important is that they don't all have the same point of view, coming from different constituencies and with different interests. This webinar is the first of a pair. The second one is not a repeat of this. It'll be building on what we are doing here today, which is why we've put a little bit of time in between the two. The next one is 3 weeks from today. And I'm looking forward to what we're doing here today, and then very much to the reactions and, as I say, building on it. Our perspective here is to take a holistic view at the entire WHOIS, or probably a better term is DNS Data Registration Directory Service. And ask less about how it is and more about what it should be, with a strong emphasis on getting all of the key perspectives from the different stakeholders, certainly from the folks who are going to be in the middle of it all, the registrars and registries, but also from all of those different parties who need or think they need the data, and how do you build a balanced perspective on all that. That's the entry into this process. We're looking at this not for those of you who think that all of this happens inside of ICANN. ICANN's principal activity in this area has been to focus on the contracted parties, that is, the so-called generic names, the top-level domains, and the registrars that serve them. That's an enormously important and large portion, but not the totality. It's roughly represents about half of the domains under management, the other half being under the country code. And the processes that we're talking about here also apply pretty directly to the names, to the numbers side of the equation, to the regional internet registries and the registries that they have for the numbers. The goals for this webinar are to try to elucidate the criteria for measuring effectiveness and efficiency. If there's really going to be a useful and effective system, then not only do we have to figure out how it should be constructed and what the trade-offs are in terms of policies, but also from an operational point of view, how does one measure whether it really is doing the job and doing it in a cost-effective fashion, cost-effective, interpreted probably differently for the different parties, but nonetheless should take into account all of those. So, as I said, that's what our objective is here today. And with that, I want to slide smoothly into our rather distinguished set of people who are going to contribute real content. Back to you, Lori, and on with the show.
Thank you so much, Steve. And Rod, you're on deck. Rod Rasmussen, noted security specialist.
Thank you, Laurie, and thank you, Steve. Yeah, I'm here to present kind of the perspective from utilizing this data for cybersecurity purposes. The goal there being to reduce online harms in as efficiently and quickly as possible. For a very long time, access to this kind of registration data was really useful and made for much quicker investigations and ability to contact folks who were affected by different kinds of security incidences. And that's been less so over recent years. Not going to get into that. Just want to talk about why folks like me and others in this field want to get a hold of this kind of data and use it. Really, two main issues here. One's real time, getting a hold of data for incident response. Right away, you can determine whether something is malicious or compromised potentially. Oftentimes by looking at that kind of registration data. And in the case of compromised websites or servers or email platforms, what have you, you can get a hold of directly a hold of the person responsible for that. And also you can link together other things in a current incident you're working on to be able to get all of the harms potentially that are going on. And if a case of a malicious registration, you can reach out to a registrar or what have you to deal with that through their processes. On a longer term basis, you can look across data to identify patterns of abuse and build reputation scores based on actual data and actual facts about things. And then you can, from that, you can look at various threat campaigns and threat actors, which is very useful for both the response and helping law enforcement, et cetera, with dealing with incidents in the long term. An important point on the cybersecurity community, they already deal routinely with very sensitive information, typically have extremely tight controls over that data and are have lots of different agreements and things in place to share that kind of data with each other on a very safe basis and within typically applicable laws across the folks involved. So that is what the cybersecurity folks are looking for, plus a lot more, which I'm sure other folks will talk to. Thanks.
Thank you, Rod. I appreciate it. And we're going to roll right along to Ignis. Oh, I'm sorry, Gabriel Andrews. I got a little bit out of the order for a second. Gabe is law enforcement, has a law enforcement perspective. And Gabe, please continue.
Hi, so Gabriel here speaking. Go ahead and go to the next slide. I think that a lot of what Rod has said in terms of what the security practitioners of the world care about also applies to law enforcement. When I talk about how we in law enforcement use this sort of WHOIS data, I tend to focus on two key aspects of our work, and that is conducting the investigations and also being able to contact victims or potential victims. And I think this is all pretty well understood, but I just want to make sure that we're on the same page about why this is so important. And that is, if you see that a domain is, for example, used in phishing, and we all know that phishing is one of the ways by which the vast majority of cybercrime is first enabled. We want to know, like, well, to Rod's point, was that domain registered by the bad guy? Was it a compromised domain? And to be able to determine what is the legitimate business that the bad guy might have talked to. Was it the registrar, or was it a proxy, or a reseller? And where does that entity exist? And all of these are very critical to us if we're trying to determine which law enforcement agency across the world has the legal authority to perhaps send follow-up legal process. If we can't find that through open source tools, we can be stymied to the investigative perspective from the get-go. Next slide, please. When we're talking about contacting victims, we might see a phishing scheme or where a bad guy registers a domain that is impersonating a victim's domain. And we might have a very limited window of opportunity to reach out to that victim and sort of infer that, hey, if the bad guy's registration was innocentvictim.com with 3 N's, well, it's pretty likely they were impersonating this other domain. Use WHOIS tools to find out who they are, reach out, try to have a conversation to prevent harm from occurring. Next slide. I want to note that law enforcement does have available to them a wide array of compulsory legal processes that they could go down, but we have a general practice, and this is true of most law enforcement agencies, can't speak for all, but we have a general preference to use the least privacy intrusive tools available, the most open source, et cetera. And we also note that as we develop facts that might perhaps justify and predicate more intrusive methods such as search warrants, et cetera, those other methods, while they can be compulsory, they can also take a lot more time. And this is especially true if they have to cross borders, in which case, on the far right of this picture, you'll see the mutual legal assistance treaty requests. At the most extreme, these are requests that might take 6 months to a year to process just by virtue of the fact that they are reliant upon international treaties, and they aren't really applicable to the WHOIS use case as a result. I'll end here, and you can go ahead and skip the next slide. It's going to be a reference if we have to return to it later.
Okay, thank you so much. We have Ignis Anfalovas.
Yeah, next slide. Firstly, IPXO is IP solutions platform with main focus on our IP leasing marketplace. And because of that, we rely on WHOIS quite a lot since we need to quickly read and update WHOIS for IP ranges added within our systems, which gets troublesome due to the fact that IP WHOIS is governed by 5 RIRs and even more NIRs within those RIRs, all possibly having different data structures. So what we would like to ultimately be achieved, and our interest here is to finally have a unifying system or framework so we could interpret and disclose IP WHOIS data easily and would not have to adapt systems for each RIR and NIR individually every time an update needs to be pushed out. Thank you.
John McElwain. John is a friend and colleague and current president of the IPC.
Thanks, John McElwain. I'm going to provide a little bit of perspective from the intellectual property attorney standpoint. So we can go to the next slide, please. And what we're going to be doing is investigating and remediating civil legal issues. So we've heard, like Gabe speak on the criminal side, lawyers would be representing clients to investigate, remediate issues from the civil side. And that's going to include things like trademark infringement, impersonation of brands, copyright infringement, theft of movies and recordings and things such as that. And in addition to those types, we're also going to be dealing with cyber squatting, so people registering trademarks and squatting on them as a domain name, and stopping various types of frauds, phishing emails, fake emails to harvest personal information, job scams, housing scams for conferences. We see them all as IP lawyers. And one of the reasons why is that an effective scam usually requires a trusted brand to attract those potential victims. So oftentimes, and again, on the civil side, we'll be brought in. But there are other reasons that are less contentious. So oftentimes we'll use the WHOIS information to contact the domain name registrant to try to purchase their domain name from them or to inquire whether they're interested in selling it. When a business is being sold, domain names can be an important asset, and there frequently are a lot of them, but they're not always well managed. So part of that due diligence process is trying to get your arms around all of the domain names that a company owns. And lastly, we utilize the WHOIS information to try to determine the date that certain things may have happened, when content was put onto a website or when a website might have been launched. So Lori, I'll turn it back over to you.
Oh, thank you, John. Next up is Jocelyn Frakes. Jocelyn, if you want to just give a little bit of your background.
Oh, yeah, sure. Well, I'm mostly known as being the co-founder of the largest conference in the domain space, NamesCon, but I've been in the business for 30 plus years, and I operate a modest-sized registrar called Plisk, just stepping out of the role of the vice chair of the registrar stakeholder group for technical operations. So I have 2 minutes and 1 slide, and I had to pack a lot into this. And I'm talking really from the registrar perspective, but I wanted to do it in a healthy way because, there's really an inconvenience here. And the inconvenience comes from, I think, two different perspectives. Those that seek to request the registration data or the WHOIS information have an entirely different set of needs and focuses. And then there's the holders who are a commercial activity that are really servicing registrars. And so we have humans that will register a domain name. These are customers that often it's very expensive to acquire a customer, and we're really trying to have a good relationship with a customer, the majority of which are really not bad actors, that are just small to medium businesses or enterprises that are operating in entirely healthy manners. So we do make sure that the WHOIS information, or now RDAP, is available. We have an entirely different set of things that we have to consider in this. The majority of the data has been, I would say, put under redaction, and there's a big focus in big tech with privacy being a major drive in today's technical world. So we do have customers who want to have their information published, and we allow for that. We also, will respond appropriately to subpoenas, court orders, and other appropriate requests. But what we do find is that the customers appreciate the privacy because they're often the recipients of massive amounts of spam, telemarketing calls, and other harassment after registering a domain name. And they often will just directly blame the registrar, but they will absolutely always call the registrar. And so we end up with quite a lot of costs in an operational model where there are very thin margins. We also have to operate the services to provide the data. And the interpretation of the data, the storage of the data, other uses of the data can often cause us additional work. We try to empower where we can. There are first-party agreements that can be made between entities in order to allow for the sharing of data and put the appropriate protections in place that will respect regulatory requirements around the processing of private information. But many registrars have had very, very difficult relationships with customers that have been driven from where their domain has been identified by, for example, a real-time black hole list as being potentially malicious. The domain gets disrupted by being reported, and then their email or website don't work. And it's very difficult for that registrant to, kind of restore service. And the registrar has a very expensive process of trying to get that customer happy again. We often will see registrants complaining about receiving aggressive notices about potentially infringing on trademarks. And it's confusing. There's definitely fora for that, courts, and you'll hear from other professionals here. Now, meanwhile, everything I've just said does not mean that registrars do not respect that the requesters are doing great things. And I come from a perspective of radical empathy about, look, I want Gabe to be able to get the bad guys. I want Rod to be able to help identify potential bad guys. I want John to be able to contact, or at least research and not contact someone to deal with an intellectual property concern. And so, it's very complex stuff. And I just identify the differences in perspectives to help people understand, it's not like a red team versus blue team kind of situation here. It's that there are simply different perspectives. So that's my spiel. And I hope that that's not too busy a slide for you. But I really thank you for your time and appreciate being part of this great panel. Thank you.
Thank you. We're on to Christine.
Thank you, Laurie, Edgemoor, and Circle ID. If I asked everyone in this virtual room, what is the purpose of collecting, storing, and allowing access to DNS registration data, we would hear different answers depending on each person's interest in using that data, as we just heard. And that alone should tell you that this is a complex problem space. But today, I'd like to share a couple of thoughts about privacy considerations for DNS registration data. Now, they may not be new, but they're worth emphasizing. Okay, and the first is a reminder of one of the core privacy principles data minimization. Collecting less personal data means there is less personal data that could be misused, leaked, stolen, or inappropriately accessed. It also means that there's less data to secure, to process, and less personal data also means that automation and interoperability is easier. And data minimization also means applying selective disclosure. The second is data security, which we, of course, should consider throughout the whole life cycle of DNS registration data. And we should be combining this with a discussion about how to take advantage of privacy-enhancing technologies to provide better privacy and security outcomes that don't depend on policy compliance. To illustrate what I mean, let's look at the messaging space. End-to-end encryption technology prevents a third party from viewing or altering the content of the message. The sender and the recipient don't have to rely on the service provider complying with a don't look policy. There are a range of technologies that could be considered in this space, especially if we're looking at use cases that only need aggregate or select information. The third is, when considering the privacy risks of DNS registration, it's important to look beyond the information that's collected for registration to consider any added risks from how domain names are used. Domain names, as we all know, are not just used for websites and web resources. They appear in email addresses, and email addresses are used as account identifiers, including even for online password vaults. And then email accounts themselves are used for account recovery. So we need to think about how could DNS registration data, when combined with other data, help attackers block access or take over accounts. And finally, circling back to the purposes of DNS registration data, don't build a solution that helps criminals, but also don't build a solution for the purpose of catching the very small number of people who might be criminals. Build a solution that works for the modern use of domain names and respects individuals' privacy.
Thank you, Christine. I am going to say that's very well noted. Thank you. And Federico.
So hi, .br has a, how can I say, little bit different perspective, because as Steve said, we are not contracted parties as a CCTLD. By the way, we are a NIR as well. So this is definitely very important for us from the perspective that having public accessible information for the registry is definitely something that brings trust to the domain name. And so challenges are actually trying to keep the real-time information through multiple protocols and having the possibility to control the use and abuse of this system in a single point. And this from the perspective of the service provider. From the perspective of the owners or holders of the services, the domain name, it's definitely needed to have a very easy to explain and understandable privacy policy, and that is actually aligned with the local legislation. And so in the case of .br, we definitely are something different from from what we generally see on the Gs, because we still keep ownership information public even after the enforcement of GDPR. That doesn't apply to us. And so, and the main challenge lies in trying to balance the level of reach and publicity with the need for maintain security for declared data in definitely in the public interest. And what the challenge that we have here is like a few actors in this field trying to push some kind of federated authentication and selected disclosure of information, and trust being something that is not transitive, brings some challenges, added challenges to that. So perhaps a more balanced way of trying to provide this information is still with not any kind of selective disclosures that we for the owners of the data, like the holders of domain names, sometimes is kind of obscure because you actually don't know for who this information will be available to. So if you have a easy to understand privacy policy and you actually know what will be public and to mostly everyone, probably it's a better way to go. And that's my initial points, and thank you very much for the participation.
Thank you, Federico. I'm going to take a little minute here before our next two speakers speak, James and Brian, to say that there are three themes running through today's program. The first theme is challenges. So we have heard from various sides of the spectrum in terms of what the challenges are, whether you're a data holder or a data collector or a data requester, because you can all be different things at different times too, as well. The second part of this conversation is about vision. What do we envision solutions looking like? How can we get to a point where there's agreements, again, on each end of the spectrum, whether you're a data collector, holder, or requester? From there, we will have a third group, and this group is going to talk about reactions to what's currently going on, proposed ideas, and where we think we might go in the future. So there's three important lessons that we've learned in doing the work with the Edgemore group. There's Dr. Crocker has been very open about engaging as many views and voices as will fit in a space, which is important. And we do have some principles that I think might be good sharing here, and then we'll move on to group 2 and group 3. The first principle is we are all united in a need for a solution. We need a solution. We need to be able to account the ideas of accountability, translate accountability into principles and standards that we can then use as building blocks for a sustainable solution. And the sustainable solution should be technically sustainable as well as economically sustainable. And hopefully those marry. Sometimes they don't. You know, laws may require disclosure, but we don't know how that disclosure is going to be paid for. That's just a reality. Or laws may require disclosure and there aren't adequate technical mechanisms to have disclosure in a measured way. So it can go either way. But it's very important that among whatever solutions we consider and eventually implement, that we are always taking into account privacy, security, economic development, and growth. And so with that, I'm going to segue into our parts 2 and 3 and introduce James Galvin and Brian Beckham. Thank you.
Thank you, Lynn. I'm James Galvin. I will be speaking on behalf of both Brian Beckham and myself. Brian, for identification purposes, is with WIPO, for those who may not know him, and I'm with Identity Digital. Brian offers his apologies. He's caught a bad cold and not having his voice today, but he is with us and he's able to keep me honest. As Laurie just said, what we've been listening to so far is a set of challenges. We've been having a discussion about what to do about registration data disclosure for many years now. And, you know, you've listened to a number of different people talk about why it's important to them and what they do with it. And the issue is we find ourselves not coalescing on an acceptable solution, something that we can all agree to. We do seem to be in a space of talking past each other. So as we begin to look at the path forward and a vision going forward, as Laurie was suggesting, a foundational point from which to start is to have some principles that we can all agree to. What are we trying to achieve? What do we need in order to achieve a future? And that's what these basic principles are. And we think about this in terms of a stool, 3 legs. And I want to highlight three, at least 3 basic principles that we believe should be present in this process. I'm going to start in the center at the bottom and talk about authentication and authorization. It seems reasonable that data holders must ordinarily know who is asking for the data. The days of an anonymous access, as we used to have, are simply not an option anymore. So, we need to be having a discussion about how it is we're going to identify all of the parties in a transaction for a data disclosure request. And then there's authorization. Even if I know who you are as a data holder still has to decide what they're going to do with that information and, whether they trust that information or not. And then given that they know who you are and trust it, what does that authorize? What does that allow? What does that give you access to? These are just questions that have to be answered. But facing the principle that we all have to deal with this is what's important here. Over on the right, we see liability. This discussion often focuses on the traditional notion in legal terms of indemnification. But the principle here is really that the subjects in the data that's being held really do need to know what happens with their data and where it goes. That's just what is true with the privacy regimes. Data holders need to be reasonably assured that the requester of the data will only do what they say they're going to do. And if there's any breach of that and a user complains, the data holder must have assurances that the requester will take some responsibility. Exactly what that looks like is an open question, but we need to have that principle that we agree we all share in the requirement to protect that data in order to achieve our individual goals with that data. The last one over on the left is automation. Automation is interesting. It's often clouded by the good old days when everybody got everything. And you saw lots of automation on the requester side to get at the data, partly because data holders, had an automated method for making the data available. All of that has changed now in the presence of privacy requirements. But the idea here is not to think in terms of automation as in it's just going to be done with nobody looking at it or watching it. The principle is that we would all benefit from efficient processing of requests. Requesters would get the benefit of faster responses. Data holders at scale could seek solutions with minimal human review, or even moving in a direction of red flag audits. It's not about automation in a pure sense. It's about efficient processing of requests. You can make bulk requests be handled separately, put them off to the side, have different kinds of arrangements for those kinds of things to satisfy the needs of researchers and other security kinds of practitioners. So the idea here is that each side, each party in this request, in this transaction, has the opportunity for efficient and fast processing. And with that, I turn it back to you, Laurie.
Thank you, Jim. I know Brian's under the weather. I also know that he's online. And so I'll just give him the courtesy, and you can even just type it right into the chat, Brian, if you'd like to. Yeah.
Thanks, Laurie. Thanks, James. I think, and James and I spoke beforehand, and we obviously agreed on these points. I think maybe just one small thing I would like to add on the automation. I think people understand that automation is probably not possible in the majority of cases because, of course, the data holders have to undertake a balancing test. But I think the quote from the UK Information Commissioner's Office is illustrative. And on their website, they actually list a number of examples that go into the reasonable expectations of the data subject. Unfortunately, they don't give an example in the domain industry. I think that's rather specific, but there are some having to do with credit reporting and things of that nature. And we've seen in practice some of the balancing tests that sort of opine on the potential legal merits of a case when we're talking about potential IP or trademark infringement, and that doesn't really seem to be supported by any of the guidance that we've seen. And I would posit that a data subject who is a registrant of a domain name might reasonably expect that if they register an infringing domain name or one that happens to get caught up in one of these types of attacks that Rod or Gabe mentioned earlier, they might reasonably expect that someone might seek the information behind the registrant of the domain name.
Thank you,
Thank you.
Brian. Yeah, thank you so much. And thank you for speaking when you're not feeling well. Um, Fortunately, it's still winter in half the world and people are getting sick. So with that, we have Steve Crocker, and Steve is going to give his own thoughts about where we are and where we should be. And I will hand it over to Steve.
Thank you very much, Lori. And as you said, three themes intertwined here, and I want to focus on the vision theme that you mentioned. What does good look like? Where are we? What would we like to see come out of all of this? Next slide, please. So very quickly, just to sort of reiterate, here are the different elements of the discussion, and then let me go through each one of those and very briefly. Don't be worried too much about the depth of this. We'll do that at another time. Next slide, please. So the environment we're dealing with has the complexity of a lot of different stakeholders coming from different perspectives. Registrants register their domain names, registrars, and on behalf of registries, on the other side of that registration process, we tend to use the term data holders to refer to them, as well as the variants of them, resellers and others that are part of that. And then you have the people who subsequently, after the registration is complete at some later time, want access to that data for one purpose or another. And there's a wide variety of requesters. And then we're not done yet, because then there's a bunch of other people who have lots to say, governments, policy authorities, various advocates from one perspective or another. So there's, as I say, a broad spectrum that makes up the environment we're dealing with. Next slide, please. So the registration process, I say, why am I bothering to say this? Well, I think it's important to have at least a reference on how this is done. So during registration, there's some interaction that takes place between the registrar and either the registrant or somebody acting on behalf of the registrant, the account holder. And a lot of data is passed from the registrant or from the account holder to the registrar. Some of it is contact information, some of it is other information, including even financial information about how this is being paid for and so forth. Plus all the operational data, what's the date of registration and how long is the registration for, where are the name servers, etc. Question that lurks around the edge of that process is, what's the accuracy of that data? To what extent is that actually correct, or is it possibly inaccurate, either purposefully or accidentally? And how much do you know about the accuracy of that data in the process of collecting it? And then an all-important question is, and what is the sensitivity from a privacy perspective of that data? Often the terms private versus public are used, but in the work that we've done, we've seen that even there are degrees of privacy. Some data is marked private, but if you try to access it, you're told, well, it's there, but you can't see it. So that's one level. And there's other data, which if you try to access it, you don't learn anything about it. You don't know if it's there or not. And a conclusion one can draw from that is, in some sense, that it's more private. And so a little bit of generalization there is helpful in untangling the future aspects of who gets access to that data and under what circumstances. All of the rules involved here as to what data gets collected and what level of accuracy is required and how that's done and what level of sensitivity is assigned to each of the data elements may vary depending upon what we know about the registrant. Quite commonly, its discussion revolves around, well, is it a business, a so-called legal person, or is it an individual, so-called natural person? But there could be other attributes that one makes a distinction about. For example, in some discussions, it's noted that some individuals, could say politicians or celebrities, are generally more at risk for having information about them disclosed. And so during the registration process, one might want to flag that their status as requiring greater protection for the details of who they are and where they're located and so forth. And the same turns out to apply not just to individuals, but even to businesses of a certain type. For example, a non-governmental organization, an NGO, operating in a conflicted zone might well regard that its physical location is a very sensitive piece of information not to be disclosed unless absolutely necessary and under very controlled circumstances. And so, as I say, an attribute different from the simple distinction of a business versus a natural person is what level of, is whether or not they're at risk of some sort, whether they require additional protection. Other kinds of distinctions include whether or not they're have a nexus in some circumstances. For example, whether or not they're a resident in the country that is part of the jurisdiction, or whether they're not, or other kinds of membership types of distinctions. Getting back to this business versus individual, one of the more interesting subtleties that I've run across, and Christine, you may have some more nuanced view of all this, is a claim that even businesses might have a lot of personally identifiable information in terms of just who they are. A small business, a very small business, a sole practitioner operating out of their residence might be legally classified as a business, but might have exactly the same risks in terms of the information that's disclosed as if they were an individual. So there's a separate, similar but distinguishable distinction between whether there's PII involved and whether or not they're a business versus a legal versus a natural person. So all these rules may depend on those kind of aspects. Next slide, please. Now, when we move to the disclosure process, there's a number of questions that come up. Who's making the request? What purpose are they making the request for? Is it appropriate? And then there's a bunch of trust issues. How do you know that the requester is who they say they are? How do you know that the requester has agreed to and can be held accountable for adhering to the rules? And how do you deal with what inevitably happens in large systems, mistakes, errors, or even purposeful mistakes, intentional mistakes of one sort or another? You can't design it. It won't do to have a system that has to be absolutely perfect, because that makes it equally absolutely fragile and will fall apart. So there has to be a reasonable treatment of things that screw up without having that being treated like a house of cards that all comes down. And on the other hand, you can't afford to have wholesale violations of the rules that you're trying to achieve. Next slide, please. Here's a small matter in a way. I've sat through many discussions about the collection of the data, the disclosure of the data, and so forth. And underneath some of the discussions is a degree of confusion. So this is a piece of tradecraft in a way. What happens if the registrar wants to know the answer to a particular question? For example, is it a business or is it a natural person? And there's several other kinds of questions. And the answer is, well, we don't know, because it's not supplied, or because even the registrant doesn't know. One of the things that's emerged out of the stuff that we've been doing is to say, well, look, rather than treating that as intractable problem or not to be talked about, so why don't we raise it up a level and say the fact of not knowing the answer to a question which ordinarily would have, say, a binary answer or maybe a small number of values, is to include the value unknown as a first-class value. And then when making up rules about what do you do with a registration that falls into a certain category, you have additional categories of including unknown for these attributes. And then you simply write the rules that cover those as well. Yes, that's a few more subcategories, if you will, but very often you can group them together. So you might say, well, look, just to focus on the point of natural versus legal person, tell me what you want to do about a natural person, tell me what you want to do about a legal person, and tell me what you want to do if you don't know. And the answer to that third question will typically be, well, in that case, treat them as, and then you pick the answer to that, but lump them with one of the existing ones. And there's usually a good rule, a good reason for doing that. That is, you make a conservative judgment about that. You might, and depending upon your point of view, you might say, well, look, if they won't tell us or we can't tell, then we're going to treat them as a natural person and protect that data. That would be biased very much in the privacy direction. Or you might say, well, if we don't know that they're a real person, then we'll treat them as a business and provide all of the data that we would provide for a business. I'm not taking a position as to which one of those is correct. I simply raise this as a piece of tradecraft, as it were, in how do you structure the rules. And in structuring the rules, you sometimes run across these kinds of stumbling blocks. And the answer is, well, let's treat those stumbling blocks as legitimate in their own right, rather than trying to sweep them under the table, as it were. Next slide. Now, another source of complexity is that everybody has their own policies. So in the basic idea of data gets collected by registrars and then gets requested later by requesters, you have the basic elements of, okay, so what should the policy be regarding data that's collected on the one hand and the disclosure on the other hand? But you also have, as we said in the survey of what the environment is, you've got registries that sit behind or above, if you will, the registrars and have their own policies. You have policy authorities of all sorts, governments, ICANN and regional bodies and the like. And these all interact. One of the relatively clean ideas that's emerged in the stuff that we've done is that it makes sense to provide a way of explicitly documenting each of their policies and then having them interact with each other. That is, you could say a registrar has its own policies, but it's also subject to a registry, and it's also subject to, say, a regional or ICANN, and to one or more governments. And if you have explicit representations of each of their policies, you can sort of lay them on top of each other and see whether or not they all fit together. And in particular, you can see whether or not the registrar is in conformance with all of the bodies that it's responsible for. that turns out to be a reasonably powerful idea, and is very helpful at untangling some of the kinds of conundrums that at least I've seen in various meetings. Next slide, please. Now, looking ahead, if you're going to try to actually implement and field a system that does all of this, things get complicated because you've got different people making policies and you've got different jurisdictions, etc. The simple conclusion is you're not going to get it all done at once, and you're not going to get it all done the same way. The really strong answer to all of this is to take a lesson from the way the internet is built in the first place. It has to be a distributed system. It has to be managed in a distributed fashion. It has to be agreement on common protocols and agreement on what the language, if you will, for policies should be. But the specific policies are then governed by separate bodies that involve each of these different different players, different organizations. Moreover, it's not a big bang. It's not like it'll all happen at once. Not only will the adoption rate vary all over the place in terms of who makes policies and when they get them done and how you implement them, but they continue to change even after decisions are made. Then time marches on, and there very natural things happen. People evolve their policies. Different groups come and go. They may merge and they may separate, and so you have to have a framework which has the flexibility of handling a multitude of policies, and this multitude does not all have to be in sync in terms of their state of affairs, their maturity, and their deployment. Next slide, please. So that leads to very strong reiteration of basic principle of separating mechanisms from policies, and you want the simplest and cleanest but most comprehensive set of mechanisms, and then you want to delegate or leave to the different parties the control over their policies and have them all fit. And one of the things that needs to be said in this process is, it might sound like this would create a big mess that's not understandable. It's also vital that not only the mechanisms have to be documented, but the policies have to be well documented. One of the bugaboos in the current state of affairs is that people make requests and they have no idea whether or not it's going to be answered, and it's very hard to get clarity about that. One of the big improvements that could be coming along if we work together on this is people should know what kind of requests are going to be satisfied, what it takes to do that, and their actual experience should match their expectations. And again, I'm not saying what the answers should be. One could imagine systems in which a lot of information is available to almost everybody. One could equally imagine a system in which very little information is available to everybody, and only a little bit more is available to others. But as I say, clarity about all of that would be a very, very big help. Next slide, please. All right, so what follows here, and I'm about to wrap up, is an illustrative attempt at trying to lay out sort of what the matrix of concerns would be for different groups. I'm not, what I'm going to show you here and on the next slide is not intended to be authoritative, but it's sort of, as I say, illustrative and, sort of approximately in the right direction. So here's a list of four different types of groups: registrants, data holders, requesters, and government and public interest groups, and a brief statement of what each of their concerns might be. Next slide, please. Oops. Next slide. Nope. Back up. So this is a slide that's not showing. Well, what's intended to be there is a matrix that simply encapsulates the previous slide. Next slide. So how do we get there? Well, I would say that there's a lot of work to be done across the entire community on clarity, efficiency, risk reduction, and reporting and auditing enforcement. Clarity is the point that I've just emphasized, that what we want, what everybody wants, is how do they know what's going to happen when requests are made? How do you know how data is going to be handled? How do you know what data is required and what accuracy level is required and so forth? And then one of the major concerns, particularly among the data holders and the registrars, is, well, look, we've got this data, and if we disclose it to anybody for any reason at all, we've taken on some risk. Why do we want to do that? And do we have to? And how can the risks associated with that somebody comes after us and says, you did the wrong thing, and therefore we're going to make life very hard for you. 4% of your gross is the common shillelagh that is waved around from GDPR. What can be done to reduce that risk for regular, ordinary operations? One idea sort of Jim mentioned something about, I think, about indemnification. A related, but in my mind, sort of more measured version of that is, can those risks be insured? And there's a lot of content underneath that kind of simple statement, because you can't have insured risks unless you can quantify them. Somebody has to take those risks. There has to be a structure there that has some stability to it, so that the risks can be underwritten. And then if you build all of that, how do you make it work efficiently enough so that it isn't just a terrible burden for everybody? Various people have spoken about that already, so I'll be super brief about all that. And then finally, what are the mechanisms that hold all of the sort of negative forces in check? What kind of reporting and visibility is there? What kind of auditing and enforcement is there, and so forth? And I would say we have not yet begun to tackle the hard parts of all of that. But although we haven't, I think they all are relatively addressable. They are not beyond the bounds of any of the complex systems that we have built in our societies in many, many different arenas. Next slide. So that's what I wanted to cover in this sense of what the vision is today. In the next webinar, we'll provide more details of the kinds of things we're thinking about. But as I said at the very beginning, we also want to focus on what reactions are to this webinar and to ideas that others may have, and fold all of those in. Thank you very much. And now back to you, Lori.
Thank you so much. So that was our visionary portion of the day. And we are going to wrap up with the reactions from 3 members of government and industry to talk about what they've heard and how they would respond. After that, I had posted in the chat, in case you haven't seen it, we will have plenty of time for a robust question and answer period. What I propose to do is those who wish to ask verbal questions, we will take verbal questions, and you just raise your hand in the chat. If you prefer to write your question, I would ask that you put a little Q in brackets and write your question. I would ask that you hold off on raising your hands or write in questions until the last speaker speaks. I will go every other. I will do a hand and a question, and we'll try to get to as many as we can. And of course, if we can't get to all of them, many of you know how to contact us directly. In our bios, there should be email addresses. You can always post comments on Circle ID with your questions, and we will answer them. So now we will get to group 3, our industry reps, and we will be starting with Dave Piscatello. Thank you, Dave.
Thank you, Lori. My name is Dave Piscatello, and I'm speaking on behalf of the research community, people who consume or ingest block lists and other reputation data and threat intelligence, along with WHOIS and DNS, to try to identify and measure where criminals acquire resources for cyber attacks. We focus primarily on phishing, spam, and malware, and we try to identify both in yearly and multi-year studies and on a quarterly basis at our Cybercrime Information Center. Where are criminals actually acquiring domains? What are they using them for? And in the process, one of the things that we do as part of our research is very similar to what first responders do. We get the reports of phishing or spam or malware attacks as quickly as we can, ingest them from 13 sources, and we collect probably over, at this point, 20 million a year. So one of the most important things for us is to be able to access WHOIS and DNS pretty much at real time, so that we can identify creation date, registrar name, name server, and other information. And the reason I mention this is because access to contact data is only part of the problem space. We can't just solve the problem of quality registration data and legitimacy of access until we actually have the ability to understand how to even get to the registrar. And the current rate limiting practices that we encounter from a number of registrars, not all, some of them are wonderful, and registries impede our efforts. As an example, we often see rate limiting of 1 query per minute. That gives us under 1,500 per day, and some registrars that we have to apply this rate limiting back query require or cause us to accumulate anywhere from 1,500 to thousands more queries than we can process in real time. The problem that we have there is that we can't identify the registrar, so that we can't measure any particular registrar performance, and that in terms of the number of cyber crimes that domains that they've registered under their management have been associated. So that's I think we don't want to just look at registration data in the context of contact data alone, because that's not a holistic approach. Earlier, there was someone who mentioned that protecting people must be the priority. One of the things that I've observed over the many years that I've been involved in the DNS and cybercrime is that the domain community often tends to consider personal data protection in the context of the registrant and the liability of the registrar and registry operators. Registrants, especially natural persons, are actually a very small percentage of the people who deserve protection. There's an entire world of users who deserve protection. If we're going to protect people as a priority, then the solution we should consider has to consider the needs of those who speak for the victims. The first responders, law enforcement, and researchers speak for the victims, and so access, it becomes exceptionally important for us. The last point I'd like to make is that the ICANN world is not the entire world. The GTLD space is not the entire space, and Steve emphasized this, and I can tell you that it is an enormous challenge to try to understand how to actually acquire registration data across over 1,500 operators. But if we have more than 1,000 registrars in the GTLD space alone, we have almost 1,500 registries. the solution that we consider here and possibly adopt as ICANN policy sometime down in the future ought to be something that could be applied in a uniform and timely manner across the entire globe. Thank you.
Thank you, Dave. And Elliot Noss.
Elliot Noss with Two Cows. Two Cows Domains has had a functioning access system for 6.5 years. I am happy to say that that system satisfies exactly the requirements that Steve laid out for a functioning system. I won't repeat them because I don't have the time. If I were to start this again, I would use John McElwain's slide title. Whose data is this anyway? Because that's simple. It is the registrant's data. While Dave's plea for the poor victims of the world that we just heard sounded good, this policy and everything we do with it applies to these registrants and this data specifically. They were, for over 20 years, the victims. They were the victims of fraud, of spam, of phishing. And nobody cared about it in the community except for the odd privacy interest and the odd registrant. We have built a system that functions for every requester noted here. And with potentially the edge case exception of mass volume real-time data for every use case that's laid out. We have published our data around queries every 90 days now for 6.5 years. In that time, about 12% of requests came from law enforcement. About 6% of requests, an incredibly low number, came from cyber researchers. The vast majority of requests came from people with commercial interests. 43% of the requests came from a single requester. I believe that we have demonstrated two important things. That a system like this can be built. I want to go back to some of the comments that Jonathan made. Concerned about the economics of these systems. Concerned about the registrars that had to answer the phone. I'm not complaining about either of those things. I am here having built a system that it was and is intended to address all of the concerns that have been described and be able to do that inside the frame of a registrar business, economically, effectively, technically. I urge everyone here, because we all overwhelmingly want the same thing, that instead of focusing on what we don't have, that what we do, to Dave's point that he just made, 1,000, 1,500 different registrars. There is absolutely no reason why compliance isn't holding every registrar to a standard that is equal to or even greater, if we talk about it, than the one that we've already met. I believe that there are great opportunities in that for an organization like Edgemoor and a project like Project Jake to provide a third-party solution for smaller registrars who don't want to build their own. I will note for you that all of these comments are in the context of the most decentralized, distributed, and incredibly functional system, technical system that the world has ever seen, and that's the DNS. There is room for a little bit of centralization here, There is room for a little bit of improvement around the edges. But my biggest complaint and biggest lament is that in 6.5 years, we have not had one productive dialogue with the requester community, and I'll use that umbrella term, about either how to improve our system or about how to hold other registrars to this standard. I would tell you that instead of lamenting what we don't have, again, we should focus on what we do have. I think the last point I want to make, so often the efforts here are complaints about what other people should do. One of the greatest challenges in this problem set is authentication. James called it out nicely. In some of our pre-meetings, Gabriel lamented, how is the poor sheriff's office in Podunk, Idaho, supposed to know what to do? We heard at length about credible security folks like Rod, who would never do anything wrong. That's great. The burden of knowing who the right law enforcement officer is or not, who the trusted cybersecurity researcher or practitioner is or not, should not be on the registrar. Each of your communities should engage in a validation exercise, an accreditation exercise inside of your own community. And that would allow us in our community to be able to help you so much more. So
Thank
again,
you, Elliot. Yeah, I'm sorry. The time is exceeded by almost twice over. I don't mean to interrupt. You have
well, we all
important
didn't get the same
messaging
amount
here.
of time, Lori. Thank you.
Yeah, I'm so sorry. But we heard you. And I actually want to intervene by saying one thing. I think this idea of having a requester town hall or whatever you want to call it with two cows could be very helpful when talking about your particular system. And with that, I would offer that I represent many requesters in my day job. Perhaps we can work that out. Okay?
Look,
I'm
Lori, I've
willing
been
to.
asking for 6.5 years. I've asked in a GAC meeting. I've asked in board
Guess what,
face-to-face.
Elliot? You didn't come to me. I can make that happen. Okay?
I actually, last meeting I was at, we sat beside each other and talked about this a little
Well,
bit.
guess what? It's happening because it was a beautiful
Excellent.
reminder. Thank
Excellent.
you. Next, we have Nigel Hickson.
Yes, thank you very much, and good evening, and I'll be very brief. Can you hear me okay? Yeah, good. So I'm Nigel Hickson. I work for the UK government in the Department of Science, Innovation and Technology, and I work on internet governance issues primarily at ICANN, etc. 3 points I was going to make. Before I make them, and they'll be very brief, I wanted to thank Steve and Laurie and others that put on this. It's been incredibly valuable, and it certainly needs to be promulgated further into the internet governance community. Secondly, I think that Steve Crocker, in his visionary remarks earlier, sort of summed up many of the policy challenges which I think we have to grapple with. And thirdly, Elliot, yes, I mean, it's like someone that's got the solution, and you keep on knocking on doors in every village you go to, and eventually perhaps someone might open the door and whatever. But yeah, no, very inspirational. So I come from a government perspective. I've got no slides. You would expect that. Governments are lazy. They're not very good at writing slides. So what does my minister want from all of this? He would have listened to the last hour and a half or hour and a quarter. He wouldn't have understood much of it, perhaps. But he would have said, I think, 3 things to me afterwards. He said this. He probably would say that the solution has to be simple. You have to have a solution where there's understandability, predictability, and where the person requesting the data has to have an understanding of when they're going to get it, how they're going to get it, etc. So the system itself needs to be simple, and it's simple to the the minister in the sense that it has to do it. You know, if we're chasing a bad guy, if we want our law enforcement authorities to chase a bad guy or whatever, we need to get the data so we can take the next step and pursue that. And really, people don't understand why that's not possible. Secondly, the tools that we the tools that we use to do that obviously is up to the experts, and people like Elliot have outlined their solution. I didn't hear, and I might have missed it because I'm getting very old, I didn't hear RDRS mentioned at all in this. No doubt, some people might comment on that. The trial that ICANN is taking forward at the moment. And so, and the third point, as well as having effective and efficient tools, the third point is that we have to work together as a community. I think we've seen that just having policy development come out of one branch of the ICANN community is not really sufficient to solve problems in this area. It requires more than that. It requires a cross-community effort where everyone comes together, shares their expertise, whether it's Brian and others on intellectual property, whether it's Gabriel on law enforcement, etc., etc. We need this cooperation. But this is a step towards it, and it's been a really invigorating and inspirational discussion. Thank you.
Thank you, Nigel. I appreciate the intervention. We appreciate everybody's time. Elliot has made a note to me that he does need to sign off. What we can do, if you have questions for Elliot, please put them in the chat and I will send them to the Two Cows team. I believe the Two Cows team may be on the call. If you are, can you please message me and let me know that you're there? And if we can do some questions to the team. So what I will do is I will take raised hands, and then I will, if there are questions chat into the chat, I will read them. So now I'll ask you to put your hands down if you help me with the test, and raise your hands if you have any questions or comments to anything you've heard today.
Lori, if I might, I see a good question.
Sure.
Actually, it's moved up a little bit. Jason wrote, when should registrants be informed of the identity of requesters? And also, when is the registrant's permission to share their identity required? Two very good questions. I can tell you what my answer would be to that, but at the moment, I'm just trying to relay his questions for everybody to respond to.
James Galvin has his hand raised.
I was just going to note that. Why don't you go, Jim?
Oh, thank you, Larry. Thank you, Steve. I was going to make a comment about Jason's two questions. I think that, those are detailed questions that fall inside of the principle of authentication and authorization. If we agree that who the parties are in the transaction have to be known, then an individual data holder is going to have their own rules for themselves based on whatever regulations or other policies that they're required to comply with about how they are supposed to use that information, where use includes, do they inform registrants or not about what's going on? There are a lot of stories about the canonical example of GDPR, and I won't get into that. But I think, again, just as a basic principle, those are fair questions, and we need to recognize that, in the basic principles, we need to talk about that and give data holders the opportunity to know what they're supposed to do. Thanks.
Thank you, Jim. So I have a question from Meilin Fung. She has a comment and a question. Legal mechanisms and laws are not keeping up with the pace of technology. The people-centered internet have proposed to the UN Global Digital Compact the concept of digital common law. This initiative might be one of the earliest beneficiaries of infrastructure for digital common law. Is there interest or actions already moving in this direction? Who would like to take that? If not, I'm happy to take that.
Go for it.
Okay, Milan, I think that is a fabulous question. I know that there's been a lot of discussion of whether the internet is a separate jurisdiction. And under current legal doctrine, we know that most laws are set up under jurisdiction. So to have this considered separate, there would have to be some universal agreement or treaty that would in fact create an internet nation, for lack of a better word. Although the discussions are there and global digital compact is on the top of everybody's mind, I would argue that if that were to ever happen, we are very many years away. This is not something that would happen in even the intermediate future. I see this as a long-term solution rather than as a short-term solution. And just to give you my background on this, I am Internet Senior Director for Internet Policy. I do follow global conversations at ICANN, at the UN, and in other fora. And again, this concept has certainly come up. There's a lot of interest in it. Where it falls, time will tell. And I wish I had more definitive, but I think people who are in favor of this, organizations who think this might be the way out in terms of policy, should be speaking up more and intervening more. Thank you. And thank you for the link. There's a link to the paper in her Q&A pod, so if all have access. If not, I'm going to put it in the public chat. We have a comment from an anonymous attendee. I appreciate Nigel's point that RDRS was not at all mentioned today, nor has the fact that there was an extensive policy development process at ICANN on this subject. Who would like to field that question?
So I raised my hand,
Okay.
Lori, to make a
Thank
comment
you.
about that. Yes, I mean, I did notice when Nigel mentioned that RDRS was not here, but I think it's important to note that Steve, in his opening remarks and along the way in his vision, noticed that, you know, ICANN is just one player, and the ICANN ecosystem is one player in all of this. So while there was extensive policy development, and some policies came out and a proposal was made and a pilot project has been going on, Jake is really looking at this, and the proposal here and looking at the larger ecosystem is that this is a larger problem. It incorporates more than just what may or may not be present in the ICANN ecosystem. So RDRS is interesting, but it's not a basis for where we want to go. It's just an observation about something that's been tried, like many other things and many of the challenges that have been talked about earlier. So that would be my comment there. Thanks.
Thank you so much. The next question, if either Reg or Sarah, we don't have the ability to talk. So what I'm going to ask Reg and Sarah to do, if they don't mind, if they have the chat, is there any chat function among speakers? Do we know? If not, I would ask Sarah or Reg to type the answer into the Q&A pod if you have that ability. If not, I will forward the question to you so that you can answer. The question was, it would be useful to understand the costs and requirements of using the 2CAL system that Elliot mentioned. I will copy and paste that into the chat for everybody. It's an anonymous question. And Reg and Sarah, you're welcome to answer in written form to me in the pod if you can, and we'll make sure that there is an answer that is given to this question. But I don't think anyone on the panel now can answer the question. The next is from Reg. I would like to hear Dr. Crocker's answer about why this is outside the multi-stakeholder model and how that attacks the credibility of the multi-stakeholder model in light of his status as a former president of ICANN.
Thank you. The form of the question is that it assumes something that I would take issue with about this being outside the multi-stakeholder model. Multi-stakeholder model, first of all, is a very general term, and I take it from the form of the question that the person asking makes a kind of one-for-one fusion between the general concept of multi-stakeholder and the specific embodiment of the way ICANN operates and the processes that are done there. an earlier multi-stakeholder model in the internet environment is the way the IETF operates, for example, where there is no divisions between different constituencies, and there's actually a very explicit recognition of small teams going off to think hard about a problem and bring back a solution, which is then run through the consensus process. The term of art in the IETF is a design team. There's nothing that nothing that we're doing here that is outside of the multi-stakeholder model at all. The essence of what we're doing is trying to stimulate discussion and careful thought. There's no authority. We're not bringing any authority into this process. We don't have any power to do that. So that's the I guess in a kind of fractured way, the answer to this. One hopes that we hope anyway that the stuff that we're doing would be informative and helpful to the ICANN processes.
All right, I want to say thank.
That's Reg axing. Oh, Reg,
Yeah.
you know better than that.
Nah, Reg is a stalwart member of the community.
Yeah.
It's all good. With all that said, we answered the last question in the pod, and I think it's a great time to round up. We're right exactly on time, which is great. Again, we're going to have a part 2. I have also suggested, and I'm going to give a shout out to 2Cows for stepping up and intervening the way it has today. It's not always easy. And that one of the sessions we may be thinking about is having those who do have offerings perhaps could give a brief synopsis of their offerings to the communities. And we have it all in one place. So people know what's out there and know what's being considered, and can also understand why Project Jake has developed the way it has, why there is support for many sectors of the community for something like Project Jake, and why organizations have been very eager to speak and participate and help build that sustainable, fair system that protects what is supposed to be protected at the appropriate time, whether it's privacy or going beyond privacy to other areas of consumer protection and cybersecurity. So with that, I'll say thank you and thank all our panelists and sign off for today.
Thank you very much, Lori. And let me just add quickly, this is the beginning of a dialogue, not the end of it. We'll see you back in 3 weeks, and hopefully be a lot of interaction even between now and then. And then subsequent events, Lori mentioned the idea of a town hall. And so that's the beginning of a discussion about what happens even after the next webinar. Lori, fantastic. Thank you. Thank you, panelists, one and all. And I hope this has been helpful to everybody. Bye-bye for now.